Okay, welcome. This is the case lecture overview of the Homaidan v. Sallie Mae case. This is a bankruptcy court case, a federal bankruptcy court case that was ultimately reviewed by the Second Circuit Court of Appeals in the summer of 2021. This is actually a very recent decision. The video that we're recording right now is being recorded in October of 2021, and this decision, I believe, was handed down in mid-July. So this is just a few months ago. And the implications are really important for a number of issues, as we'll talk about in this lecture, including the obligations for repayment of student loans under bankruptcy law, general interpretation of bankruptcy law at the federal level, and the precedents that this sets for future cases moving forward. At the same time, there was also a relatively surgical lens, through which the Circuit Court of Appeals reviewed and rendered an opinion on the case that left a lot of questions unanswered. And so, as is typically the case, especially at the appellate level, these cases and the courts tend to be very specific and to not address or, overstep into broad questions that don't speak to the specific facts of the case before them. And so what that leaves is many more questions to be answered by future courts and future cases. But it's important to note as we move forward that bankruptcy courts, there's a compilation of bankruptcy courts at the federal level that oversee bankruptcy proceedings. Aside from the bankruptcy courts, you have a number of different kinds of federal courts. Federal district courts are the most common kind of district court or court for hearing cases at the federal level. And cases can be heard in district courts based on a number of different circumstances, but there's two primary ways you find yourself in federal court if you don't have a specific subject matter like bankruptcy that calls for a bankruptcy court at the federal level. If you're just going to district court, for example, you can get there by way of what's called diversity. And this would be the circumstances under which if no one plaintiff has a common convenient venue with any one defendant, that is to say that they don't share a state of residence or a convenient forum for litigating a case, and the subject matter in controversy between them has a dollar value or an approximate dollar value that exceeds a certain threshold, and currently that threshold is $75,000. It's been that for quite a while now. Then you can establish federal court jurisdiction by way of diversity. And that is to say that if there's not a convenient forum for any of the parties, then federal court kind of serves as a neutral ground for these more significant dollar value cases to be heard at a place that ostensibly would not have a home team advantage for one party and an away team disadvantage for the other. So for example, if I live in New York and you live in California and you're suing me, well, if we litigate in California, you've got a convenience and an advantage there. But if we litigate in New York, I've got a convenience and an advantage where I live. So neither one of those are ideal. And obviously, we're not going to litigate in Kansas state court just because it's halfway between us. We would litigate in a federal district court, and provided, again, that our subject matter of controversy exceeds the $75,000 threshold, we could establish that we have diversity jurisdiction to remove the case to federal court. And this is a very common tactic among big corporations and entities that have a benefit to get away from the local venue and local forum of smaller courts, state courts, and municipal courts, because you can kind of understand from their perspective that if you have a local community member who was injured, let's just say in a grocery store or a big box store or a movie theater or a theme park, then they're the community member that lives down the street where most of the jury may find a personal connection or relationship to them. And on the other side of this case is a massive corporation like, let's just say Walmart, for example. If that were the case, there's a perception issue, right, that may work to the disadvantage of Walmart because they're having to litigate their case in sort of the backyard of the plaintiff, where they might be able to elicit more sympathy by virtue of the fact that they're a local community member. So there are understandable tactical implications around diversity jurisdiction in federal courts. The other way to get to federal court is through federal question, right? That is to say, is there a question of federal law? And that's really what bankruptcy courts are, in a sense. They are dealing with federal law. It's just that they're a very specific forum for the subject of bankruptcy, because bankruptcy proceedings, number one, are very complex. There's an entire area of legislation dedicated specifically to bankruptcy procedure and bankruptcy law, and so it's a separate forum for a separate, very specific, very technical kind of litigation. And so this is why we have a separate series of courts for bankruptcy courts. And that's what we had in this case. But the circuit courts of appeal that preside over the different jurisdictions will hear cases on appeal from the district courts and from the bankruptcy courts alike. And so in this case, the Second Circuit Court of Appeal, which I believe oversees the states of New York, Connecticut, and Vermont, if I'm not mistaken. It's the Northeastern Territory. This was the bankruptcy court for the Eastern District of New York that presided over the original case with Homaidan, and then it was reviewed by the Second Circuit Court of Appeal. It's important to note that the Second Circuit Court, really any appellate court, is never obligated to hear an appeal. They can take on appeals based on the application for certiorari review, but there's usually not a compelling force that demands a certiorari review or an appellate review. And both of these things happened in the Homaidan case, incidentally, is you had a Second Circuit Court of Appeal that agreed to review the case, and that's really what we're going to be talking about today. But incidentally, as we'll talk about and is actually alluded to on this title page slide that we're looking at, there was an attempt to have the case reviewed at the highest level, the third level beyond the Circuit Court of Appeal, and that would be the Supreme Court of the United States. Because at the federal level, there's three levels. You have a district court, or in this case, bankruptcy court, which is essentially a district level court. Then you have the courts of appeal, and then you have the Supreme Court. And that's pretty common in even state level jurisdictions. It's not completely uniform across the United States, but it's common to have three levels. And so that is the case at the federal level. And incidentally, the appellants tried to move this up to the Supreme Court, and that certiorari claim or application was denied. Right. So the Supreme Court, in other words, decided not to hear this case. And so all we have is the remand from the Circuit Court, which is what we'll be talking about today. So with that in mind, as we move forward, just some legal terminology review for what we're talking about. And this is important in any kind of appellate case, because the terms we use to describe the parties can become a little bit confusing, and it's easy to get lost. So at a trial level, whether you're in bankruptcy court or you're in district court or any other type of court, you have the plaintiff and the defendant. So essentially the party that is suing and the party that is being sued. It's appropriate to use sort of a catch-all term like party, because those individuals, of course, can be, or the folks, the entities on either side of a case can be individuals. It could be one individual, it could be multiple individuals, but it could also be entities like companies, corporations, LLCs, governments, right? Municipalities, state level, federal level. So there's a lot of different potential variations in terms of who might sit on each side of the aisle in a case like this. And normally the vast majority of cases are far more complex than just Jones v. Smith, sort of a 1v1 situation. Usually there are multiple on both sides, or at least on one side. A lot of cases stemming around, for example, personal injury, depending on the circumstances, will have, of course, the plaintiff, the victim, and it may be one, it may be multiple. If you have a class action, then you could have thousands or tens of thousands, right? And they'll be suing one or more entities, right? It could be a manufacturer and all of their distributors. It could be a franchise and all of their owner-operators. So there's a lot, the styles for different cases, as we call them, right? The headings that denote the parties can become extremely complex. And there's a lot of the Latin term et al., right? Which essentially just means and everything else. So there can be a lot of parties, right, to cases like this, far from just a 1v1 scenario. Now, when we talk about appeal, it's important to note that we're talking about appellants and appellees. And these don't necessarily have any direct correlation to plaintiff versus defendant. When we talk about appeal, we're talking about an individual filing an appeal and another person defending the appeal or responding to the appeal, right? One who wants the case or the verdict or the decision to be appealed, and the other who does not, right? And this is interesting because we often think, well, naturally the person or the entity or the party that's filing an appeal would be the party that loses at the trial level. And that might be true, in some cases, but not necessarily in every case. You can have an individual who quote unquote wins, right? And I'm putting those in big air quotes because, of course, the idea of winning a case is subjective, right? It depends on your interpretation of what you want and what you're getting, right? But you might receive an advantageous verdict on a case or a decision on a case, but also one in which you feel like you could have done better, right? And one in which you said, well, yeah, we kind of won and we got some of what we wanted, but I feel like this is, you may also feel that the court erred in some way, that they failed to consider certain evidence that they should have, or there was a procedural mistake. And so it's not at all uncommon for a party that, again, quote unquote, wins a case, might appeal even on a relative victory in hopes that they might, be able to overturn some aspect of the case for the sake of improving their situation even further. So a defendant can be an appellant, a plaintiff can be an appellant. It all just depends on the decisions that are made at the trial level and whether or not the party feels that they're just and wants that review. So it all just depends. There's a lot of circumstances here, and we'll be talking about that, of course, in the context of the Homaidan case. So moving forward, some more legal terminology here to clarify. Motion to dismiss. And this is also known as a 12b6 motion. The only reason why we call it that is that's the number of the motion under the Federal Rules of Civil Procedure. It is a motion to dismiss a case for failure to state a claim upon which relief can be granted. And essentially, that's just the idea that, look, either party, but generally it's going to be the defendant, will want to throw out a case. A plaintiff could throw out a cross claim or a counter claim, right? If there's another party suing or counter suing them. But generally it's a defendant, at least with regard to the original claim, that would attempt to throw out a claim. And it's basically asking the judge to say, look, there's nothing here to litigate. There's nothing here to argue about because the facts are quite clear and the law is quite clear, and there's no controversy, right? There's no dispute over what happened, how it happened, and what rules apply. And so basically 12b6 just says there's nothing to be done here. This is a frivolous or ridiculous case, and it should be thrown out as beyond the time and attention for the court, that it's not worthy of being litigated because there's nothing to be disputed here. And so the decisions on 12b6 motions are made by the judges. They're not made by juries. Interlocutory appeals are appeals during a particular set of litigation, right, or litigation at hand, to things like motions, right? So it could be a motion for a 12b6, as we've just discussed. It could be a motion for summary judgment. There's a number of different ways to establish, or means by which you might go about establishing an interlocutory appeal. A number of different reasons for that. Parties can directly appeal a court's order in certain situations rather than having to wait for the entire course to go through the entirety of the process. And this challenges, again, a non-final trial court order that decides an issue but does not result in a final judgment on the case, right? So with respect to 12b6 motions, it's important to note when we're talking about this, we're talking about what is most often a dismissal without prejudice. And what does that mean? When we talk about cases that are dismissed without prejudice, essentially when a judge agrees with a motion to dismiss, but doesn't dismiss it in such a way that precludes it from being retried or refiled by the plaintiff or whoever's bringing the claim at some point in the future. So just say that a case is dismissed without prejudice just simply says, look, we're throwing this out as it currently stands, but that might just be because there's a fatal flaw in the way that the complaint is worded or some omission that needs to be addressed or corrected. And that happens fairly commonly. And so if you have that, a dismissal without prejudice just means, look, you refile. You fix the issues and you file it again, and then your case may be sufficient to go to trial. A dismissal with prejudice is just the opposite. And again, that's more rare. It's very uncommon that would happen with any kind of a 12b6, like a peremptory motion to dismiss before anything's been heard, because a dismissal with prejudice just says, look, we're dismissing this case and you can never file it again under any circumstances. So it's a permanent dismissal of the subject matter of the case at hand under any circumstances. And so it carries a lot of weight in that regard. And as such, judges tend to be reluctant to do that unless there's a really compelling reason to do so. So just to keep that in mind as we move forward. And then again, we'll be talking in this discussion about the Homaidan case on the bankruptcy code, and specifically the components, section 523, subsection 8, subsection 8. You can refer to that and look it up if you like. But what we're really going to be referring to, and we'll cite the exact language in this discussion, is the exceptions to dischargeable debts, meaning what kind of debts, if you file for bankruptcy, can you have discharged by a court? What kind of debts can a court say, okay, pursuant to your bankruptcy order, you no longer have to pay this, versus other kinds of debts that a court does not have the jurisdiction to do that with, where certain debts are non-dischargeable. And an example of that, as we'll talk about, is child support or criminal fines, right? The kinds of debts that a court cannot waive, regardless of your financial circumstances or how sympathetic they are to your bankruptcy situation. They cannot waive those. They cannot discharge them. You will owe them no matter what. So the question is, in this specific case, where do student loans fall in that? And specific to Homaidan, what is a student loan, quote unquote? And it'll get interesting as we talk about it. So why are student loans not dischargeable? And that is the current case, that student loans, again, quote unquote, student loans are not dischargeable. So a little bit of a short timeline here to understand. And a lot of this hinges on sort of the political leanings of different presidential administrations and what has happened over the course of the last 50 or so years in our country. But if we go all the way back to pre-1976, which again is about 50 years ago, student loans were dischargeable debt under bankruptcy law. So they weren't looked at as anything different than, say a credit card loan or a car loan or a mortgage payment. These are the kinds of things that could be discharged by bankruptcy courts if the circumstances of the bankruptcy proceeding are found to be genuine and sufficient to establish that, the debt should be discharged. So that's where we are on this. After that period, the law was changed so that no government or nonprofit loans were dischargeable debts within the first 5 years of payment. And so when you think about trying to put yourself in the seat of the legislator in thinking about why has there been so much movement on these rules and why is it so controversial? Well, you're trying to balance the interests of the lender and the lendee, right? You're trying to create a situation that is fair to loan companies that want to be able to lend money to people without being left without any recourse if a person who takes out a loan defaults on that loan, right? That's not entirely fair to the lender, provided that they didn't do anything nefarious. So if I agree to lend you money and you agree to pay me that money back in installments at a set interest rate and a payment amount, and then a year in you say, I'm sorry, but I either can't pay you back because I don't have the money, or I don't want to because I don't feel like it, whatever the circumstances are, I should be able to force you to honor our commitment, right? I mean, just under the basic premise of a contract, right? But obviously, we also recognize that there are circumstances that are unforeseeable and outside the control of individuals that can lead to difficult, impossible even financial circumstances that can make paying back loans impossible. And so there is an impetus for compassion in that regard. And the key that legislators have to wrestle with in this sense, and why we're seeing sort of fluctuation over time, is that it's trying to balance that, right? What does that mean? How do we support lenders, but also consumers in the sense of lending? We want to encourage lending. That's good for the economy, but we don't want to leave lenders without any recourse when they don't get paid. And we also want to recognize that, sometimes bad things happen that are beyond the control of people, and offer them some way to get out from under a mountain of debt that they may not have been able to handle through circumstances, again, that they had no way to foresee or control. So in the specific case of Homaidan, again, as we're going to talk about, his bankruptcy was in 2009. And if you remember 2009, a lot of people were filing bankruptcy, right? This was right after the subprime mortgage lending crisis. The housing market collapsed, the auto market collapsed, the stock market collapsed. It was a terrible economic time. It's known as the recession, right? The Great Recession in the US. And so there were a ton of people filing for bankruptcy at this time. And that doesn't mean that all of those people were financially irresponsible. It was just an unprecedentedly terrible economic period for our country that left a lot of people in desperation to remove the burden of debt that they had carried. So under this balancing situation post 1976, if loans were issued by a government or a nonprofit, right? It's important to note that doesn't denote private institutions. They were dischargeable debts, but not within the first 5 years, right? So this covered lenders and their expectations of payment within 5 years. But after 5 years, they could be discharged if there's a showing of undue hardship. And we haven't gotten to that yet, but we'll talk about what undue hardship means in this context, right? So moving forward again, 1984, we're now into the 80s, the conservative Reagan administration. The Bankruptcy Amendments and Federal Judgeship Act of 1984 made it so all private student loans were accepted from discharge, right? So this has added to the post-1976 change in the law. We've already talked about government and nonprofits, but now we're adding private loans as being accepted from discharge, meaning non-dischargeable. You have to pay them regardless of whether or not you have a successful bankruptcy proceeding. So this sort of moves one step further in the direction of lender protection. Right. In 2005, Congress passed the Bankruptcy Abuse Prevention and Consumer Protection Act of 2005. This has a somewhat ironic name. Again, another conservative Republican administration. This was George Bush. Made it so that no student loan, federal or private, right, could be discharged in bankruptcy unless the borrower can prove repaying the loan would cause undue hardship, right? And there's that term again. But this condition is very difficult to prove unless someone has a severe disability, right, that would preclude their ability to work, to earn a living, to do virtually anything. So you better be a quadriplegic in order to establish undue hardship in this context. And it's interesting, the reason why I emphasize this is that undue hardship can have different meanings in different legislative contexts. For example, undue hardship is a term that can be found and used in the context of Americans with Disabilities Act law. When we talk about public access and accommodation for people with disabilities, specifically, for example, mobility impairment. So if I have a building that is a hotel or a restaurant where people are supposed to be able to go, but my building was built in 1908 before elevators were commonplace, and yet I don't have an elevator. There's no way to retrofit an elevator into my building. Is it reasonable to expect that I should have to demolish my building and rebuild it because it's not in compliance with the 1990 ADA or the 2009 amendment to the ADA? No, of course not. That would be absurd. That it presents an undue hardship on me to have to do that. So there may be an exemption for me, right, under those contexts. But of course, here when we use the term undue hardship, we're talking about the context of loan repayment and what would be established and what would be sufficient to discharge a loan that would otherwise be non-dischargeable, right? And so here, that bar is very, very high and certainly outside reach for most people. And so again, up to this point and to the present, student loans are considered the same kinds of debts as child support and criminal fines, which means they are simply beyond the pale for discharge. They're just not dischargeable. But the question, as we will come to talk about in the case with Homaidan, is what is a quote unquote student loan? Where do the lines start and stop with respect to that term? So the background on the Homaidan case. So plaintiff appellee, student named Hilal Homaidan, attended Emerson College in the 2000s. And so in order to pay for his education, he takes out quote unquote direct to consumer private educational loans from Sallie Mae, right? Navient Solutions is the successor to Sallie Mae, right? So they take over loan administration for Sallie Mae after the origination with Sallie Mae itself, and they handle the student loans that Sallie Mae distributed. So this is important and interesting in considering the decisions of the court, as we'll talk about. When Homaidan received the loans from Sallie Mae, they went straight into his bank account. They were not issued to the school, as a lot of student loans typically are. They were given directly to him to use, and ostensibly any way he would like, because there wasn't a policing over, which dollars went where. So there was a pretext on the loan that it was called an educational loan, but the money was given directly to him and not to the school. Additionally, the loan proceeds that he was given exceeded the cost of his tuition. So there was no direct matching between the tuition amount that Emerson was charging Homaidan for his education and the amount that he was given by Sallie Mae. And one would expect that with an educational student loan, that loan would be intended to satisfy the obligations of whatever the costs of college are. Now, that could be tuition in some cases. It could be tuition in books. It could be tuition in books and room and board even. But there was no attempt to match the amount between what Sallie Mae was sending Homaidan and what Emerson was charging him. And this is important when we think about the context of, was this really a student loan? And that's a hinge point in this case. So Homaidan again received the loans and graduated from college. He later had to file for Chapter 7 bankruptcy to discharge his debts. Again, 2009 was a rough time for a lot of people. And so in 2009, the bankruptcy court issued the discharge order for him. So he successfully went through the process and had most of his debts discharged. And so that was a process he went through at that time that alleviated him of his pre-existing debts moving forward. Now, after the discharge order, Navient, again the successor to Sallie Mae, who was administrating the loans and collecting payment, pursued him for repayment. In fact, they even went so far as to hire a collector, a debt collector, to go after Homaidan to repay the loans. Right, so they pursued him for repayment in spite of the 2009 order. So Homaidan, not knowing better, pays the loans in full, assuming that he had to pay them. So he didn't know better. And when Navient went after him, he said to himself, well, if they're coming after me for payment, that must mean that these loans were not discharged in the bankruptcy order. Otherwise, why would they be after me? So he pays them. But in 2017, he has apparently a moment of clarity or enlightenment. And he says, hey, why in the world am I paying these back when they should have been discharged pursuant to my bankruptcy proceeding in 2009? So in 2017, he moves to reopen the case on the assumption that he didn't have to pay them back in the first place. So why this didn't occur to him before he repaid Navient is unclear, but 2017 is when he makes the connection and he decides to bring this up. So Homaidan alleges that Navient violated his 2009 order when they attempted to collect repayment from him on the direct-to-consumer loans. They're classified or labeled by Sallie Mae at the time they originated as, again, student or educational loans, but they're also classified as direct-to-consumer as opposed to directed-to-educational institution. And so he sought actual damages from Navient's alleged violation because he was harmed. So obviously the damage would be, number one, pay me back my money because I never should have had to repay you for these loans in the first place. But it goes beyond that. And you can argue that, look, where else would he be in his life if he didn't have to pay you that money? What would he have used it for? How could he have furthered his financial situation since then? So is he owed interest, right? Things like that. There's a number of factors when we consider damages. That goes beyond the scope of most of the conversation for today, but just something to think about, that his claim may have exceeded just whatever he paid them. It may be, in addition to that, what else is he owed? And as we'll talk about, his claim was more than just a mistake on Navient's part, and this is important. So procedurally, again, the United States Bankruptcy Court for the Eastern District of New York was the court that originally heard the proceeding in 2009 for discharge of Homaidan's debts. The petition in bankruptcy court listed the two Navient loans as debt liabilities, so it was listed on the court proceedings as some of the debts that Homaidan owned. or that he carried at the time he went through the bankruptcy proceeding, but it didn't directly address them specifically as to whether they can be discharged under the bankruptcy code. So there wasn't a direct link to yes or no, right? So the bankruptcy court generally discharged his debts, but nothing specifically addressing the Navient loans one way or another. And this is what led to the ambiguity that catalyzed this case in the first place, because it was, at the very least, it was unclear as to which way that swung. So as a result, the status of the loans, again, was unclear. It was ambiguous. So in 2017, Homaidan reopens his bankruptcy case, and he wants to see whether the loans from Navient, or originally from Sallie Mae and then eventually administrated by Navient, were they in fact discharged pursuant to the 2009 order, or were they accepted as Navient would suggest. So again, Homaidan argues that the loans were discharged, and so he didn't have to repay them, and therefore Navient should give his money back. In addition to that, it's also interesting that this claim, I want you to just think about what this means, because he also asserts malice beyond the scope of just simple mistake or negligence. He's asserting that Navient knew this and was doing it intentionally as almost like a fraud scheme. He's alleging that, look, you knew your loans were dischargeable in bankruptcy, and you solicited them and sold them to unsophisticated student borrowers, in other words, young people who didn't know better. And then even after they went through bankruptcy proceedings, you still went after them for repayment because you knew that they weren't likely to contest it, because again, they were, in your view, naive, and perhaps maybe even in fact naive as to the case, because to be fair to the parties here, Homaidan paid them, right? So he's even looking at that as evidence, is like, look, I didn't know better and I paid them back to you, and it took me years after to wisen up to you and eventually sue you to get you to give my money back. But how many other people didn't? And so he's going so far as to allege that Navient is doing this dubiously and with malice, as opposed to just, hey, they made a mistake. That would be negligence, right? But he's establishing a case for fraud here. So Navient argues that the student loans were not discharged and had to be repaid. They're simply saying, no, the 2009 bankruptcy court order did not discharge our loans because they're student loans, right? And student loans, as we've established through the history we discussed previously, are not subject to discharge. So that's their simple defense, straightforward. So in the bankruptcy court, the judge determines that the Navient loans were not accepted from discharge under the bankruptcy code. In other words, they weren't separate from discharge. What that means is that they were discharged, right? That they were part of everything else that was subject to discharge. So Navient should have never come to Homaidan asking for the money. So basically, they're saying, yeah, we agree with Homaidan on this case. The debts were discharged. You had no business going to him with your hand out asking for money. He didn't have to pay you back. So you're going to have to give it back to him. So Navient had filed a motion to dismiss the case, again, the 12B6 that we had talked about, saying, we want you to throw this case out because it lacks merit. And because the court agreed with Homaidan, at least initially, they denied the motion. They said, no, there's just no way. And so Navient is the one who appeals, again, by way of an interlocutory appeal, to the court to review this. And so Navient argues that their two loans were not dischargeable debts under the code. And so the bankruptcy court was wrong in its decision. So basically they're saying, we understand that the bankruptcy code reviewed this and found that our debts were discharged in 2009, but we disagree with that on the grounds that, again, as we previously established from the history, it's been pretty clear in the establishment of bankruptcy law that student loans are non-dischargeable. So that seems to run contrary to the bankruptcy court decision, which is why they asked the circuit court to step in. So the Second Circuit Court of Appeals had jurisdiction to review the bankruptcy court's order. Again, the Second Circuit Court of Appeals would also oversee district court cases that were on appeal, but in addition to that, they're overseeing bankruptcy court cases, and so this is a Second Circuit appellate case. The court affirmed the bankruptcy's order denying Navient's motion to dismiss. So essentially, the short version is they denied the motion as well. They agreed with the bankruptcy court in terms of denying the motion to dismiss, which doesn't mean that the case is settled, right? It doesn't mean they're deciding on the merits of the case. They're just saying the case should certainly go forward and not be thrown out preliminarily because you think it lacks merit to move forward. There's certainly enough here for the rest to move forward. So following that, Navient, as I mentioned earlier, appealed to the U.S. Supreme Court to say, hey, we disagree with the circuit court and we want you to look at it. So again, you have these three levels, and if you're not happy with the first appellate level, and assuming you can get support and agreement to hear your case at the third level, you're free to do that. But of course, the U.S. Supreme Court is very limited in its time frame and capacity. There's 9 judges, and they have limited bandwidth for this, and also they're very specifically picky with respect to the issues they cover, because they know that there is no higher level, right? So the Supreme Court needs to be very careful with the decisions that they hand down, because of the way that this changes the nature of judicial interpretation, of legislative interpretation. Their decisions carry immense weight in our society. So they don't hear every case that comes up for appellate application. They turn down far more than they hear, and this was one of them. Right? So looking at the background law in terms of what informed the circuit court's decision, or rather the bankruptcy court's decision and the circuit court's decision to agree with the bankruptcy court. So again, going back to bankruptcy law, 11 U.S. Code, the Bankruptcy Code immunizes certain liabilities from discharge, including most educational debt, right? So what that means is that there's certain areas, again, that are beyond the pale of discharge, cannot be discharged in bankruptcy. Yet there are some debts that cannot be discharged. And again, this is the specific reference to that in the code. Exceptions to discharge: an obligation to repay funds received as an educational benefit, scholarship, or stipend, right? So specifically listed. So again, Navient files their 12B6 motion to dismiss. And under these grounds, when we talk about the Federal Rules of Civil Procedure, when you're filing an answer to a claim, this paragraph under the Federal Rules basically just says, you need to state that alongside your responsive pleading, meaning your answer. But a party may assert the following defenses by motion at subsequent times, and one of those, again, is 12B6. And 12B6, again, as I stated at the onset, failure to state a claim upon which relief can be granted. The basic idea being, look, there's nothing here. There's nothing to litigate. There's nothing to dispute, because everything is quite clear. And that was the allegation, or the plea that Navient made to try to have the case thrown out, and it ultimately failed. And so the interlocutory order, the jurisdiction of a court of appeals to hear the issue, their challenge to the trial court, the bankruptcy court's motion. So again, the district court in this case, the bankruptcy court, certifies that the order involves a question of law for which no controlling precedent exists, and the appellate court authorizes the appeal. So if there is a good faith question and the appellate court is willing to hear it, then the interlocutory order can go forward. That's essentially what this section is saying. Okay, so with respect to legal issues, on appeal, again, as we've discussed, whether the private student loans at issue, meaning the direct-to-consumer loans that were issued originally by Sallie Mae and then carried by Navient to Homaidan, whether they constituted, under the code, an obligation to repay funds received as an educational benefit and are therefore accepted from discharge. So that's the key question. Are they considered student loans? So the court reviewed 3 categories in terms of debt that cannot be discharged. And this is key because there were 3 categories, but only one was really determined to be relevant in the eyes of the Circuit Court of Appeals. So the first one, as you can see here, loans and benefits backed by the government or a nonprofit. Neither one of these apply because Sallie Mae is neither one of these, right? We're talking about a company that issues direct-to-consumer loans. So they're not the government. They're not a nonprofit. Number 1 is not relevant. Number 2, obligations to repay funds received as an educational benefit, scholarship, or stipend. This is the key. This was the piece that was subject to scrutiny in the Homaidan case. Number 3, qualified private educational loans as a specialized definition. Even that is a little bit ambiguous and has not been clearly defined or scrutinized by the courts, but it was determined in the Homaidan case to not be relevant to the facts. And so that was thrown out. And the key issue, again, was number 2. Is this were these, the direct-to-consumer loans, were they funds received for educational benefit, scholarship, or stipend? And so that's what we're going to talk about moving forward. So again, court determined that these three components, that the first two, or the number one and number three rather, did not apply. So the only remaining component was number two. The court turned to the statutory provision to determine whether a loan is in fact, again, an obligation to repay funds received as an educational benefit. So a court doesn't just do a field test in terms of how things sound, on the tongue. There's a number of different ways that they scrutinize this, and this is what we're going to look at in the preceding slides. So three different kinds of methods or strategies that are used by courts to interpret something that is not clear. So in other words, when you have a term like a loan or an educational benefit, how do we determine what that means? Well, the law was written by legislators, but all that the courts can do after the law has been written is try to make educated estimations or assumptions with respect to what the legislators intended when they use certain words, right? We are constrained by our language. And so when we have a certain word that could be potentially ambiguous as to its meaning, and where that ambiguity is critical to the decision in an important case, the courts have to approach this carefully to make sure that their interpretation of the meaning is fair, right, under the circumstances. So there's three ways to do this: plain meaning, canon against surplusage, and canon of non satur associ, right? So we're going to talk about these as we move forward. So as we do, canons of statutory interpretation in the case. Plain meaning is perhaps the most easily accessible and intuitive. We're talking about what the ordinary meaning of a word or a term is. And so when we talk about obligation to repay funds received as an education benefit, what does that mean ordinarily, right, to the layperson, conversationally, so to speak? Well, when we talk about the case, legal doctrine, insofar as plain meaning, courts look to the whole statute to interpret a term, not just a particular clause. So they're not going to restrict themselves to that one subparagraph in the entire chapter of bankruptcy law. They're going to look at the entirety of the law to see if there's any context to be useful in interpreting what that word or term means. So they'll also look at congressional intent. Sometimes there are legislative notes around legislation, different laws that were passed, subnotes or footnotes or subtext that can help to support the understanding of the legislators, right? In other words, what did Congress mean when they wrote this, right? They use this word for a meaning, but what is it that they meant? So if Congress explicitly includes particular language in one section of a statute and omits it in another, they don't assume that to be coincidence or an accident, right? So if they see that something is included in one place but not found in another place, the assumption from the courts is that that was intentionally done, right? That there was a reason for that choice. So under a plain meaning reading of the statute, if Congress had intended to accept all educational loans from discharge, it would have explicitly said so, right? So basically, that's what Navient would like the circuit court and the bankruptcy court to believe, right? That's what they wanted them to declare, was that, look, what Congress meant is any educational loans that were even ostensibly given, for any relationship to an educational purpose, right? I give you a loan and I say, I'd really like you to use this for college, but if you want to use it for a new car, go ahead. I can't stop you, but I'm just telling you that it would be nice if you used it for college. Well, is that a loan that's intended for educational benefit, or a quote unquote educational loan that should be discharged? Navient would have preferred so, right? They would have preferred that the court say, yes, anything that is listed as an educational loan is discharged no matter what, or excluded from discharge, right? Meaning it's protected from discharge in bankruptcy proceedings, and for obvious reasons, right? So they're saying an obligation to repay funds received as an educational benefit covered their loans, and so they cannot be discharged. And so they wanted to convince the court to read the word loan into the language, even though it didn't include that word. And we'll be talking about that because that's important, so that it would include every student loan and not just those backed by governments or nonprofits, as we discussed previously. But again, the court noted that that word was absent from that particular provision, right? It was expressly included in the others, in the immediately preceding and subsequent provisions. So it was covered in the qualified loans and the government and nonprofit loans, but it wasn't present in the second component that we just talked about. And again, where that occurs, the courts don't assume that Congress did that by accident. They assume there was a reason why they left it out. And so they were reluctant to agree with Navient on that point. However, based on the plain meaning of the statute, the court disagreed with Navient's interpretation. So again, the term loan wasn't included in the provision of the code that was at issue, that second component, and Congress did not intend for the word loan to be there, right? So in other words, if it's not present in 2, but it's in 1 and 3, then there has to be a reason why. So the court noted that the term loan was included in many other parts of the statute as well, but not in that specific provision. So the second component, canon against surplusage or surplusage. Canon against surplusage for statutory interpretation. This particular strategy for interpretation of legislative language advises courts to look in such a way that no part of a particular statute will invalidate another, right? The idea that you can't read into a statute in such a way that it would render moot other language, right? That would be nonsensical. So you've got to try to read into the language of a statute in a way such that it's consistent with the operability of all of the components, right, that exist. So essentially how that's relevant to the Homaidan case when we're talking about this is that Navient wanted the court to interpret the statute so it would include any loan and would not be dischargeable under the code, right? I mean, they would like very much for that because, of course, then their loans would be protected and they would have been in the right for going after Homaidan. But again, as we talked about, the court rejected the interpretation. But under the argument for surplusage, the court found this is a different reasoning to reject Navient's argument. And the reasoning is that if they did that, it would draw every student loan under any conceivable context into the exception for dischargeable debts, meaning everything would be protected from discharge. And if they did that, then the whole purpose of Congress's delineation of the 3 categories that we discussed, government and nonprofit, the second component that's at issue here, and the third component, the qualified loans, would be entirely pointless. There would be no meaning to that whatsoever, because it would have the effect of nullifying any specificity to that. Why even bother to enumerate 3 specific criteria? Because if they were to agree with Navient's argument, there would be no purpose to any of that. All loans would fall for any conceivable educational purpose would fall under protection from discharge. And so it would essentially render that entire component of this legislation inoperable. And so again, it would create a catch-all provision as non-dischargeable debt. And clearly it was not intended by Congress, again, the presumption that the court makes, that this component of the law would invalidate the entirety of the law. I mean, that can't have been their intent with respect to this section of the U.S. Code, right? And then finally, our last component here, canon of nocedor soci. This canon is often used by courts to interpret a statutory term within the context of other terms that are also left undefined by the statute, right? So again, if a statute doesn't come with a glossary that gives us a clear interpretation of what each word means, we're left to our own devices to try to figure that out, right? And so this helps to give undefined words, particularly the most meaningful among them, when we talk about loan, when we talk about educational benefit, right? In this context, it helps to establish a meaning by reference to relationship with other words or phrases in the context of the law that we're looking at, right? So it prevents the court, in addition to that, from giving a particular undefined term or word a definition that is outside the scope of Congress's intention. So it constrains them to the language related to it in the statute, which would obviously, by virtue of sheer logic, lead to a definition or an interpretation that is probably more consistent with what was intended. So the disputed term here, when we're talking about this last canon, is educational benefit. So we've talked about loan in the first component of plain meaning. We've also talked about the inoperability that would be rendered if Navient's argument were to move forward. But now we're talking about the educational benefit that's present in the second criteria, right? And what we want to understand is, what does that mean, right? It was undefined and potentially ambiguous. So what does that mean in the context of the law? What was Congress trying to say? And so Navient, again, the defendant, argued that educational benefit covered student loans and was therefore not conditional, right? So essentially, when we talk about the term educational benefit, we're referring to student loans. And so the court went so far as to look at the other terms that are included in that criteria, because the word scholarship appears there, grant, that were listed in the same exact provision right alongside it, to see if we can establish a common theme, right? What do these three things have in common, in other words? So the court determined, when we look at scholarships and grants, that one of the common themes among these, as they have conditional payments that don't necessarily have to be repaid if certain conditions are met, right? In other words, for example, for grants and scholarships, oftentimes if you have athletic scholarships or military scholarships, a student who meets the qualifications of that grant or that scholarship might not have to repay the terms of the loan, provided that they adhere to them. But if they break the conditions, then they have to repay them. So there's a contingency, right, built in to that component. And so that's the educational benefit. So the defining characteristic of a loan, by contrast, as Navient was arguing, is one and the same with this, is that loans have to be repaid no matter what, right? And so this was a key distinction that the circuit court offered in its opinion, is that, look, when we look at this second criteria and we see educational benefits and we talk about scholarships and grants, we're talking about things that are potentially free of a repayment obligation, provided that, again, the student in question meets certain conditions and maintains them. But a student loan must be repaid regardless, right? Most student loans don't have an opt-out or some type of, you can do this thing and then you don't have to pay it back. And yes, there's student loan forgiveness programs at the federal level, but that's really something different from what we're talking about, because they don't originate as grants or scholarships. If the federal government wants to retroactively initiate a forgiveness program, that's separate. But the original intent of the loan is to be repaid no matter what, right? And so that's what a loan is at its core. And that's what the circuit court opined here. So as one of the terms in the list, the court determined that educational benefit was best read to refer to conditional payments, right? With a contingency that you do something so that you don't have to repay it, right? Like scholarships and stipends, and did not cover private student loans that carry an expectation of repayment no matter what. So that was the point of separation between what Navient offered to Homaidan, or what Sallie Mae offered to Homaidan and that Navient collected, versus a grant or a scholarship. So what are the results of the case in terms of Homaidan? So the court denied the lender's motion to dismiss, as we talked about. They concluded that the language of the statute, which accepts from discharge an obligation to repay funds received as, again, educational benefits, scholarship, or stipend, doesn't cover the type of direct-to-consumer private student loans that Homaidan was given by Sallie Mae, or that he took out from Sallie Mae back during his education at Emerson, right? So that they are separate and distinct from. And so the Second Circuit Court of Appeals, after going through the lower court's analysis, agreed with the bankruptcy court's interpretation, right? So there was no daylight between the reasons why the bankruptcy court denied the motion to dismiss and what the circuit court found in analyzing that decision. So it affirmed the order denying Navient's motion to dismiss Homaidan's position, or their petition for review of the motion to dismiss decision. So at least two other circuit courts of appeals have reached this conclusion independently in other cases. So it seems to be a trend. Circuit courts are not necessarily obligated to adhere to the precedents that are set by other circuits. So there can be an independent sort of decision that could even be contrary, or at least ostensibly contrary to other circuit courts, but there should be good reason, right? I mean, generally, courts and panels of judges will look to precedents that have been set, particularly in their own circuits and their geographic areas, but also outside, right? Because the circuit courts of appeals, there aren't terribly many of them, right? They cover large swaths of the country. And so they have an interest in trying to keep some level of judicial consistency. And so there is a tradition of looking outside the court to make sure that, hey, if we're going to render a decision on a particular case, we want to look at what the other courts have done and see, ought we fall in line with this decision and the logic of the decision because the cases are close enough in fact pattern and issues of fact and law? Or is there a distinction in our case that is significant enough that would compel a decision that deviates, right, from that tradition, from that trend line, for reasons of different facts or different circumstances that justify, right, that explain why you would go a different way? So that's not certainly outside the scope of a circuit court's discretion to do, but it must be done with good reason, right? That it can't be done arbitrarily. So again, Fifth Circuit Court of Appeals and 10th Circuit Court of Appeals. Fifth Circuit, I believe, is Texas and a few other areas of the country, and then your 10th Circuit Court of Appeals as well. So key things to keep in mind, though, in terms of unanswered questions here. The court's decision created some uncertainty over the status of private student loans. So although we addressed the Homaidan case in terms of the specific loans that Sallie Mae issued and that Navient is administrating, other types of student loans, right? When we're talking about, for example, what if the student loan from Sallie Mae had been sent directly to the educational institution? Right? What if it had been for exactly the amount of the tuition? What if none of those other extraneous factors were present? Would it still be considered a direct-to-consumer or private student loan that was exempt? It would seem so under the logic of Homaidan, because it seems the decision was based more on the fact that it was a loan as opposed to and it was made by a private company as opposed to a contingent program where, again, a grant or a scholarship where a student could do something or maintain a certain status to alleviate the need to repay the loan. But it's yet to be determined. There, again, are still questions to be answered in that vein. Neither the bankruptcy court's order nor the Second Circuit's decision to support that order determine the circumstances under which loans may be discharged in bankruptcy under the code. Right. So we still haven't heard the merits of the case and allowed it to continue. So there's still more work to be done on Homaidan. Right. All we've really done at this point is settled the issue of the interlocutory appeal over the motion to dismiss. Right. So that has been rendered at this point dead. Right. That the motion to dismiss has failed. It's been denied by the bankruptcy court, and it's also been denied by the appellate court, and the Supreme Court has denied review. Right. So there's nowhere else to go on that. But the case is still ostensibly moving forward. And there seems to be, an expectation of which way it will lean. But that's essentially where we are in the proceedings. And if it does, it will set a precedent. But it doesn't mean that everything is completely over at this point. Last but not least, the court did not consider whether the private student loans at issue are quote unquote qualified education loans and thus not subject to discharge under the code. So that was the third component, if you remember. And again, there is some specialized meaning to that term. But again, it does contain the word loan, which was part of the concern that the circuit court had with respect to the arguments coming from Navient in this case and criterion number 2. Because criterion number 2 did not contain the word loan. Well, criterion number 3 contains this qualified education loan language, which sort of alleviates the concerns about that whole contingent repayment issue that you find in number 2. In other words, you don't have to deliberate about, was this a grant or a scholarship? No, it's a loan. But what is a qualified education loan? Right? What does that mean? What was the congressional intent? And again, we'd have to go back to our statutory interpretation strategies, our canons, right, to plain meaning and so on and so forth, to try to deduce that. But the reason why the Circuit Court of Appeals here neglected to go that far was, once again, it was not relevant to the facts of this case. They were limited to criterion number 2. That was the only component that was relevant as they saw in this case. And that's what they opined on. They did not go outside the boundaries of the specific circumstances of this case, which is the precedent, that is the tradition among court opinions. And bankruptcy courts will have to take up that issue, obviously, at another time with future cases. So what does it mean for Homaidan? Again, Homaidan can continue the litigation against Navient. It doesn't mean it's over. There's seems to be momentum in the direction of which way this will go, but that doesn't mean that it's completely settled or resolved or the case is closed or that a verdict has been rendered. It just means the motion to dismiss has been denied and it's going to move forward. Again, also keeping in mind, he had alleged what I would describe as malice, right? Predatory lending practices that, that they were issuing these private education loans to what he describes essentially as naive loan borrowers and then tricking them into repaying the loans. And that essentially they knew what they were doing and they were doing this intentionally, to get around bankruptcy orders that cut them short of their repayment. And so this is a different claim altogether because it's not simple negligence. It's an accusation of essentially malice and fraud, right? Deception tactics. So that's going to be an interesting component of this case as we move forward, and we'll continue to watch it. If he's successful, he might be able to collect damages against Navient at a minimum, get the money back that he paid them, because it seems like there's an argument here quite clearly to establish that he didn't owe them that money in the first place, assuming that's the final verdict in the case. And then furthermore, I mean, who knows if he also wins in his claim that Navient is using predatory loan practices, he might be eligible for damages related to, pain and suffering and anything else he can argue that, they intentionally hurt him with. So this is truly open-ended with respect to where this could go from here. So concluding, some private loans can be discharged in bankruptcy court and are therefore not accepted from Chapter 7 bankruptcy. And this obviously opens the door for more student loan borrowers to seek debt relief. Potentially based on this precedent, we may see a much larger push among people with bankruptcy proceedings to try to be relieved of their student loan debt. But it's yet to be seen, whether this will establish a broad precedent that will apply to many cases or just very narrowly to a few that are most closely aligned with the type of individual that Homaidan was and the type of direct-to-consumer loan that he received from Sallie Mae originally. That will ultimately be determined by the precedents and the cases that follow from this and how they interpret it. Okay, well, that brings us to the end of our lecture for this case. I hope you found it useful, and I will see you next time for another great case lecture. Thanks, everybody, and have a wonderful evening.